Good evening, good evening, good evening. This is Attorney Vince Davis, and these are the 8:30 p.m. Pacific Standard Time office hours. Office hours is where I answer a question that has been asked of me by someone through a post or an email or a phone call. And this evening's question is from a grandmother. How do I get my grandson out of foster care? It's a damn good question. I get so many of those questions about relatives trying to get a child out of foster care. It's almost as if, sometimes, that the law doesn't exist. And I'm talking about the law that makes it the preference for the child to be placed with a relative. You know, I'm involved in another case right now where the grandmother wanted the children, and instead the social worker gave the children to kind of a distant family friend. Now, under the law here in California, where I'm licensed to practice law, relatives have preference over distant family friends. As a matter of fact, the code gives us a preference for certain types of relatives that have preference over other relatives. So, for example, grandma trumps second cousin once removed. Well, that makes sense, right? But sometimes I get the feelings that the social workers are not following the laws, but instead doing what they think is best, or at least doing what they think would benefit them and their position. Do social workers sometimes have interests which are different from the family or the children's? Yes. And it seems like sometimes nobody ever wants to hear about that. So, how does the grandmother get the child? The first thing that I would advise the grandparent to do here in here in California is to file a 388 petition. We talked about the 388 this morning in office hours, but it's the same thing. It's that magic motion that can be used to get yourself out of jail. By the way, if you're the grandparent and you want to get the child and the social worker says no, we're going to leave the child in the foster home, if you accept that without going to court and without challenging it before the judge, you're not going to get the grandchild. That's just plain and simple. So you got to go to court. Unfortunately, don't rely on the social workers to do the right things, because in many cases, not all, but in many cases you're going to be sadly disappointed and there's not anything that you can do, and you're going to lose that grandchild to the foster parents through an adoption. I think a couple of days ago during office hours I talked about a case in Riverside, where the relatives waited too long to come forward to try to get the child out of foster care. Don't wait. The longer you wait, your chances start decreasing. So don't wait. Don't think that, relative placement is always the law and that it will always be implemented. Because, when I first went to law school, I learned law says blah, 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 blah. But then there's 100 exceptions in case law. So don't rely on what you think the law is, because generally as a civilian you're not going to know what the law is. The law says this, but the Court of Appeals says, and the Supreme Court says, well, the law is a little bit different, really doesn't mean what it says. And we have these other exceptions, judicial exceptions, that which are the law in California. Okay? So 387 petition. That consists of the form, which you can find on Google. It consists of legal points and authorities. It's mentioning not only the statute, but the cases that interpret that statute. So you want to have legal points and authorities. Now here's, the bottom line on all cases in juvenile dependency court. Evidence and procedure. Evidence and procedure. Everyone's always talking about the substantive law, what the statute says. But you got to have evidence to prove your case. Citing the law without evidence gets you a goose egg, a zero. I was in court, this is several months ago, and I was watching a trial. And the social worker and her attorney input the reports, the detention report, the jurisdictional report, the dispositional report. And then the judge goes by each one of the attorneys, the attorney for the child, the attorney for the mother, the attorney for the father, and they all say, we're going to argue the case. That's a recipe for disaster if you're a parent. If you're going to argue a case, you better have dumped some evidence into the case so that the judge can consider it. Argument by doing a trial by argument. The Court of Appeals here in California has said on many different occasions, argument is not evidence. Words that your attorney says, that's not evidence. And if it's not evidence, the court is not supposed to rely on it. So, I chuckle sometimes, but it really hurts me because I think, those parents don't even know what's happening to them. They think they're having a trial, and they're not really having a trial. They're having something that kind of looks like you're having a trial if you're a civilian. So, evidence. In California, there is something called the California Evidence Code. Has many sections, and it tells us what evidence is admissible, what evidence isn't admissible. It tells us the exceptions for things like the hearsay rule, character evidence, and then there's all the case law, the appellate courts and the Supreme Court that interpret those statutes. Sometimes, as you learn in law school, the statute, the words don't mean what they say. I know that's hard to accept. The first time I heard that, I thought, what's going on here? What do you mean it doesn't mean what they say? So, you got to know your evidence. And unless you're a lawyer with experience in this area, bad enough you probably don't know the law, but if you did know the law, do you know the evidence, how to get the evidence in that's going to help you, and how to keep the evidence out that's going to hurt you? Probably not, unless you not only went to law school, but you have some experience in these types of cases. You're also going to need, the exhibits, which is part of evidence. And, when I do a 388, I try to include declarations from witnesses. I include certificates of completion in certain classes. I include letters of progress in counseling. Maybe throw in some, character letters. You get a 50-50 shot on the character evidence. So I throw, pictures, videos, all that kind of stuff. So when I say file a 388, I don't mean filling out the 4-page form and turning it in. That's not going to get you very much, in my opinion. It's a low probability move. So, at least talk to your attorney to find out if he or she can assist you in doing the 388 petition, because you doing it by yourself is not going to be a good idea. And everybody in California has an attorney that's going to represent them. Either it's going to be a court-appointed attorney or a private attorney that they hire. In the very rare case, I once in a while will see a judge allow a parent to represent themselves. But that's, that doesn't happen very often. So you're always going to have access, court appointed or your private attorney. The next thing I'm going to tell that grandmother to do is file a de facto standing motion. There's a form for that. But like everything else, you should have legal points and authorities. You should have the evidence, declarations, pictures, videos, letters, character references. Now, here's something I get all the time about the 388. Mr. Davis, your 388 is going to lose because the grandmother never took care of the child during the pendency of the case. And I'm here to tell you that is not the only standard for getting de facto standing in California. There are several cases out on this issue. You can have taken care of the child before the case even began, and you can get de facto standing. So if they try to limit you to taking care of the child during the pendency of the case, they're misleading you. Now, there's another way to get standing in California without ever having taken care of the child. So a lot of attorneys will tell you, well, you never took care of the child, so you can't get de facto standing. That's not true. There is a case in California, an oldie but a goodie, called N. Ray Charles S. Google it. N. Ray, R-E, Charles, space, S, period. N. Ray Charles S. What Charles S. tells us is that if you are a relative and you come to court often, that you have an interest in the child such that your viewpoint or your evidence should be heard, and that you should be given some type of standing so the court will listen to you. A lot of times your grandma on a case, they won't even let you in the courtroom, or if they do, you have to sit in the back and you have to be quiet. You don't get to tell the judge anything. The reason is you don't have standing. And what I learned in law school over 30 years ago, 34 years ago, you can't talk in court to the judge and present evidence unless you have standing. So, in California, if you're not a natural parent or a bio parent or presumed parent, or there's several different types of parents in California, you can get standing through Charles S. So take a look at that case and use it if you've never taken care of the child. The third thing that I would recommend to the grandmother is to disclose the records. You got to get a copy of what the evidence is that's being used against you. Now, I'm going to tell you a story. And even when I tell people this now, it's hard for me to believe, and I experienced it. I did a trial for some relatives who wanted to get the child in San Diego County. And the social worker's attorney was allowed to use reports of the social worker that I didn't get to see. So they'd be introducing into evidence against me that I didn't get to see. How crazy is that? So you have to make a motion to disclose the records. In that particular case, I made a motion to disclose the records just for the purposes of that trial, and it was denied. And the trial happened, like that day or the next day or something, next week. And we didn't have time to go up on appeal. So make your request to disclose the records to you early, so if you ever have to go to a hearing or a trial, you'll be able to see the evidence that they're going to use against you. The next thing I would recommend for the grandmother to do, and this is a lot of people think I'm crazy when I'm about to tell you. File a petition for temporary and permanent guardianship. I don't think I've ever had any attorney or judge for that matter, maybe one, give my petitions for guardianship any serious consideration. Now I'm going to tell you why I recommend to do this. It adds a different layer of complexity, complex to the case. Can someone in juvenile court do a probate type petition in juvenile court to get guardianship? My belief is yes, because the basic law is anything that you would have done in another courtroom regarding custody and visitation of the child is now trumped by the juvenile court. But in my opinion, there's no rule that says you can't file what you would have filed in that other court in juvenile court. There's a rule going the other way, all right? But there's no rule that you can't file things in juvenile court that you would have filed in the other court. So, and when we're talking about guardianship, we're talking about probation, the probate court. So, take this into consideration. You know, I've been doing this 31 years. I've been an attorney 31, and it's something that you should consider. Now, of course, talk to your lawyer, be it court appointed or be it private, and get their opinion. And I always recommend people, even if it's against what I say on these videos, follow your attorney's advice. Okay? Now, the last thing I had for Grandma to recommend to her today was she was out of state. And, you know, I told her, well, maybe can you come here to get the kids? And, you know, does your schedule and work and financial position allow you to do that? But if you ever want to go back to your home state, you have to get something called ICPC approval. And I've talked about that before, the Interstate Compact for the Placement of Children. So you might want to request of the judge that an expedited ICPC be ordered and performed. Expedited ICPCs take, I think, a maximum of 30 days. If you don't get it expedited, you could be literally waiting for months for a social worker in another state to do your home study and your ICPC approval in the foreign state. So those are the 5 things that I have to recommend to the grandmother trying to get her grandchild out of foster care. Now, you're probably watching this video because you or someone you know has a CPS case. Now, I answer questions like this every day, seems like all day. Right before I started this office hour on Facebook, I was getting a couple texts from people asking me questions about CPS cases. So even at 8:30 a.m., 8:30 p.m. at night, people are still asking these questions. Check my website out because there's a lot of resources there. FightChildProtectiveServices.com. And also look at my videos on YouTube. Just go to YouTube and in the bar type Vincent Davis and my YouTube page will come up. Also on Saturday evenings on ABC Radio in Los Angeles, KABC 790, the radio show, which this page is named after, The Secret, Fight Child Protective Services and Win, airs every Saturday at 7 p.m. to 9 p.m. You can listen to it live at KABC 790 Talk Radio in Los Angeles or in the Southern California area, and you can also catch it on kabc.com live streamed, and you can catch it right here on Facebook on this Facebook page, The Secret, How to Fight CPS and Win. Okay, and also if you want to call me, try to set up a consultation, 888-888-6582, 888-888-6582. We'll see you tomorrow morning on morning office hours at 6:30 a.m. Pacific Time. Have a good evening.